Today we're going to be talking about citizen lawsuits, specifically around how to prevent, litigate, and also settle Clean Water Act citizen lawsuits. So the financial implications around stormwater litigation, that fines and lawsuits is probably the number one financial implication in your stormwater program. We talk about some of the others around, potentially your pollution liability going up from a premium perspective, maybe just internal time and costs. But you'll see with any kind of stormwater litigation, not only is it going to be a payout in penalties or settlement, but also your own internal staff time spent dealing with stormwater lawsuits. So it's really something to pay attention to and not ignore. So a couple reasons why companies get sued across the board. Sampling data, like I said before, you really want to know where you're at as opposed to benchmarks action levels at any given time. It's one of the reasons why, from a software perspective, it's front and center. You're seeing what your trends are in real time. You're not waiting till the end of the year. Or in the case of one lawsuit, 131 times they collected stormwater samples, submitted them, and never checked that they were over. And it ultimately cost them about $5 million for those 131 events. Sampling data will get you in trouble every time. Make sure you're not just taking it, submitting it, forgetting about it. Missing reports, big flag. You miss an annual report. It's often, especially with this electronic reporting, it's a big flag. But also just crappy sitemap SWPs, goes back to this electronic reporting. It's easy to pull this information. And I almost guarantee if I were to pull SWPs, I could tell you pretty quickly who is likely to have other problems in their stormwater program, just looking at the quality of their sitemap and SWP. Is it robust? Is everything there? Has it been updated at least on an annual basis?
You don't want to go through that hassle litigation. You've taken a hard look at it. You realize that you're probably going to settle this for a lot less than it's going to take to litigate it. So what does that settlement mean? What does it look like? There's you can either have an in-court settlement or an out-of-court settlement. If they filed the complaint, you're going to have to. It's too late. You're in it. You're going to settle in court. If you engage the citizen group in the 60-day notice period, you can agree that they will not file the complaint while you negotiate a settlement, which is usually a good idea. Even if you end up not coming to a settlement and litigating, it's usually a good idea to engage them and start at least feeling what's out, where they stand on settlement. There used to be a thought that in-court settlements provided notice, obviously, to other people that you were sued, so they didn't come behind and file suit. And also, there's something called claim preclusion, that people can't sue if you've been sued on the exact same issues. The problem with that is if somebody really wanted to sue you after you've been sued, they can just allege different violations. So I'm not sure how effective that would be. People were concerned about out-of-court settlements. Most of the ones that I do now are actually out of court, and I've never had another environmental group come behind and sue on it. And the environmental groups that I've worked with and the plaintiffs' counsels that I work with on these settlements have said that it generally doesn't happen. And if somebody were to send you a 60-day notice, that they would say, hey, we're already working with them to clean up their stormwater program. And that usually takes care of it. And the cost that you save for out-of-court settlement, most of my clients, that's the path that they choose, is to settle out of court. There are two general types of relief that you'll see in settlement, whether it's a consent decree through a court settlement or out of court. There's injunctive relief, so they're going to require you to do specific things. All of this is negotiable. So this is just a contract negotiation. There's going to be give and take. And there's going to be monetary payments, obviously, that they're going to want. They want paid. So for both the activities that they've done and to fund future activities. And then there's going to be changes to your operation that they're going to require, which is kind of what the injunctive sort of relief. So what are the injunctive terms? What are they going to do? What do they want? They're going to be in your business for 2 to 5 years. Most of these consent, that's the length of the consent decrees. They're going to want some sort of oversight. You're going to file generally a yearly report to the citizen group. That's on top of whatever reporting you're doing under your general permit to through the SMART system. So 2 sets of reports. They're going to want to come look at your facility, maybe during the rainy season and the dry season. They're going to bring an expert. I would highly recommend that you have an expert there too. A lot of times attorneys will say, don't don't say anything during inspection. If they ask a direct question, answer it, but don't offer anything additional up. I found if you have a good consultant and the two consultants start talking, it actually works out pretty well, because their consultant will see something, and I've had consultants on site that say, well, no, it's because we do this, and they explain it, and they don't end up, they end up saying, oh, okay, that makes sense, and they don't put it in a report. A lot of times they'll do a site inspection and then they'll file a report. If you have any disagreement with those reports, send a response back to them. Don't let anything lie. If they got something wrong, make sure you send it, back to them saying that we disagree with you and here's why. The other thing they're going to want to do is review your SWP, and they're going to want to comment on your SWP and your reports. In these settlements, I think it's okay for them to comment. I would respond, but I wouldn't put any provision in there where you have to reach consensus with the opposing party. It's okay to disagree. Thank you for your input. We've agreed with you on A, B, and C. We've made changes, but we disagree with you on 1, 2, and 3, and we think what we've done will show improvement. So again, it's very important to have people who understand the stormwater business, understand BMPs, working with you on these issues. So the settlement payment terms, again, attorney's fees, always attorney's fees. I'm not sure how you get out of this process without paying some sort of attorney's fees. They're going to want a payment for environmental project funding. It's basically mitigation payments. Under the Clean Water Act, there are the civil penalties. So instead of paying civil penalties, you pay to an environmental project. Sometimes that list that I showed you of the common people who bring these types of suits, sometimes they'll suggest that you pay one of them. I usually say no, because I don't want to fuel them suing other people. The Rose Foundation, I found, is pretty good to actually go out into the environment here in the San Francisco Bay Area. They go out to the Bay and do cleanup work. So the money actually goes to mitigation, actually goes to clean up the environment. They'll also request that you pay for their expert to come do your site inspection and to review your SWP, to review your program. I would make sure under that provision that there's a cap, and that you only pay for what they're charged, and that they provide an invoice for that. But then negotiate a cap that they can't go over per year, or whatever makes sense from a business standpoint. And then there's always stipulated payments. If you don't, the consent decree or the settlement agreement is going to have a lot of due dates, both for filing reports, for implementing additional BMPs, for paying them money. There'll generally be a penalty if you fail to meet one of those dates. So make sure you put somebody in charge of the consent decree, compliance with the consent decree. To me, it doesn't make any sense to pay an attorney to send you emails 2 weeks before a due date. It's better to have it done in-house. What I wouldn't put in a stipulated payment is if you have an exceedance of an NAL or other trigger level that they want, and I'll talk about that. They don't necessarily stick just to the NALs or the permit. I would not make that a penalty. That the permit's not set up that way. The Clean Water Act's not set up that way. It's designed that if you have an exceedance, you go back in, look at your program, improve your BMPs, and see if that works. It's an iterative process. You shouldn't be paying an automatic fee or fine or penalty because you have an exceedance. So the typical terms, they're going to want you obviously to update your SWP because they're alleged that it's deficient. Install additional BMPs. The trend recently has really been for structural BMPs. I would set the settlement up so that, again, it's an iterative process so that you can start low and work your way up. Some of the non-structurals, regenerative sweeping, filtration on drop inlets, revisions to your processes and procedures, material handling and storage, additional training for facility employees. These settlement agreements are going to say, if you have an exceedance after your initial set of BMPs, you need to start looking at structural BMPs. So unification of discharge points, new or increased stormwater settling capacity, tanks or vaults or ponds, modified stormwater treatment system, those types of activities. It's a good idea to not make them specific, give yourself a range, one of potential structural BMPs that he could choose from depending on whether there were exceedances. So we're not pigeonholing ourselves into anything specific. There's a variety of options for structural BMPs. Another typical settlement term is that they're not just going to stick to the permit. A lot of times they're going to want a matrix, not a matrix, but a trigger that is more strict than the NALs. So they're going to have potentially lower levels, potentially more constituents. They also try and tie, which I would fight to the extent that you can, these settlements tie exceedances to benchmarks of the California toxics rule. You'll see that frequently. There's some bad court decisions out there that tie EPA benchmarks in the California toxics rule to end of pipe sample results. I think it's a bad decision. I don't think legally would hold up if it were challenged. It's a lower court decision, so it doesn't set precedent. But the problem is nobody has challenged it because these cases generally settle, and so nobody wants to pay to take on that fight. The other thing to consider is that you're going to have to make concessions. I had a client where they wanted to test for metals, and the client's SIC code didn't require metals testing. We went back and forth and we fought them on it, and they said, okay, well, we want, instead of some of the NALs are average NALs, you average them over the year. They said they wanted us to do instantaneous NALs for the first year of the consent decree. And the consultant said, oh, I think we can handle that. We can keep it clean. It shouldn't be a problem. So we got them to back off of testing the metals, and this was an industrial area of Oakland, where I almost positive, even though they weren't required to test for metals, they would have found metals in their stormwater results. So it worked out good. I guess the bottom line is you need to take a close look at what they're trying to tie you to, whether you can meet it, whether it makes sense from a business standpoint, and how much you want to fight on a particular issue and how much you want to give. So that leads into the settlement tips. Pick your battles. There will be compromises. This is a negotiation. They don't want to go through the expense of litigating any more than you do. They would rather have a nice, clean settlement if you can agree to terms. Make sure you have a good consultant that's helping you and your legal team through this process. Try to keep as close to the permit terms as you can. Have your reporting date similar. Try to stick to the NALs. Don't do benchmarks. Don't do California toxics rule. If they want to lower the limits and you can live with it, try and work that to your advantage as much as you can. Again, I just mentioned leave flexibility on the BMP implementation to the term of the settlement. You want performance-based standards, so if you meet, you only have to increase the BMPs if there are issues, and depending on the severity of the issues, that's how you're going to react with BMPs through the iterative process.